For orders item 1.
Alright, so far as the state of Assam is concerned, my lord, if your lordships may kindly have a look at the last order passed on 2nd of August. There were 2 paragraphs which relate to the state of Assam. In the first paragraph, my lord, while we have a lordship said, my lord, mentioned about the status of the development of judicial infrastructure. Towards the end, my lord, your lordship directed in the second paragraph, last line, my lord, the learned amicus curiae engaged in this case to therefore file his response. And the next page, my lord, this is with regard to standard design and plan for construction of public toilets. There, my lord, your lordship directed us that therefore an action taken report be placed on record within 8 weeks. And I have received the instruction. So as far as the infrastructure is concerned, my lord, we have received. Lordship may kindly have a look at this one, the forwarding letter, my lord. In inviting the reference to the above, I am directed to state that the reports have been called for from the PWD Judicial Department and all the district commissioner regarding the up-to-date status of action taken in the matter of WPC so and so. However, till date, reports have been received in respect of 13 districts only. Accordingly, a compiled report have been prepared and enclosed at Annexure 1. In this context, this is to state that government is pursuing the matter with the concerned authorities on priority basis. But despite efforts and reminders, copy and post, we are unable to get the inputs from the remaining districts from remaining 22 districts and PWD Judicial Department. In view of the above, you are requested to apprise this honorable court accordingly and move the honorable court for allowing another 1 month time for submission of the status report for the remaining districts. So whatever report we have received, we have annexed. And my submission will be, my lordship may keep it on record, and when we receive the remaining, we'll file a complete report. And then lordship may take a call. So
this report is regarding the infrastructure.
Infrastructure.
Or the.
Yes, but that is why they are unable to give the total status report with regard to the standard design and plan for construction of public toilet. This I will submit on the next day, my lord, along with this, along with the complete report of all the districts, remaining 25 districts, and the status report with regard to standard design, because it has been mentioned here that it has been approved by the chief engineer PWD. The design we prepared.
So you want to submit the complete report on the next day?
My lord. Remaining 25 districts they could not give. They have been writing, but 13 districts they have received, which we are here, my lord, already. So the lordship will give us some time, my lord, in the meeting.
And what about the? So there are 2 issues here.
Yes, so far as Assam is concerned, my lord.
One is the infrastructure. Other is about the toilets.
Toilets, the design we have prepared, that has been approved, and we'll have to go ahead, and your lordship directed that to place on record the action taken report. That I'll submit on the next day, my lord. I'll find out what is the action.
Okay, Mr. Majumdar, tell us one thing. What is the present mechanism of when the residential accommodation of judicial officers is opted through the district administration?
My lord.
What is the mechanism followed? Are you aware?
I'm fully not aware, but from time to time, whatever report.
Rented accommodation and Milord,
No,
where
lordship is asking about the mechanism. Possibly, my lord, the district administration, along with the district judge, they find out if there is if the requirement of land, whether it is to be acquired or it is to be purchased or
rental.
Residential, through the deputy commissioner, it is being the search is made through the deputy commissioner with the
in some places search are made through the deputy commissioner,
Yes.
and in some places the magistrate are searching for their own accommodation. They are opting for rent.
Yes.
So is the approval of High Court required? Mr.
Well-
Bodua, is the approval of High Court required in those matters? Residential accommodation, rented,
The function of the High Court is required also.
on what basis?
Normally, DC make requisition of those rented houses, and they inform district judge, and district judge writes us, and accordingly we place the thing before the committee.
But why is it necessary? Why High Court should get involved in residential accommodation?
Normally this procedure is for we have followed logic, because funds are just High Court is extending those funds logic for budget.
No, but residential accommodation, High Court is paying the money.
After requisition logic, they can do it. Yes, logic. Yeah, so which provide.
Are you saying that when a judicial officer occupies a residential accommodation on rent,
Yes.
the money is paid by the High Court?
I do not think, my lord.
Yeah.
Huh?
I could provide budget to the district and district. But.
So, but the procedure provides the budget. Ultimately, source of funding the state. Procedure.
My lord, exact status, I'll find out. Your lordship mentioned somewhere, my lord, passes an order, I'll find out the exact procedure. If, as my learned friend is indicating, if the budget includes this provision also for
But why should High Court pay the?
no, but
outright-
ultimately the state, from the state's exchequer, the budget allocation will be
No,
paid.
it will come, the officer will have to bear it from the HRA. These are not free accommodation.
My lord,
The officer gets house rent allowance, is it not?
Yes.
So the help is only to the extent of
yes, making it
If the
available.
rent is, my lord, paid by the, either by the High Court or by the state, the officer will not get HRA, my lord. He will not get HRA.
Possibly it will be treated like a
That is
quarters.
the-
my lord. Quarters is treated for all. Quarters.
He pays from his own pocket, then he is entitled to HRA.
No, it is not.
Ms. Chaudhary, can you- today it's an incomplete report, will not.
But it seems to be on the right track, your lordship, the meeting which they have held on 19/7/2024 identifies, and the next page, if your lordship, you will see an extra flag B of the report. There, I also identified the quantum of
Oh.
money which will be required for each person which will be engaged.
Decision
So
prices.
step forward, lordship, the state government perhaps will be required to answer as to what.
Look, this
would
is
be
the
their-
entire compilation. Look, this is the entire compilation of the action taken.
Very good.
This is-
Flag B of that compilation, your lordship.
Like D,
B.
D for Delhi.
No.
Who has
B for Bombay.
prepared this compilation? You.
No,
From the
from
registry.
the
money.
registry.
Which one? This one?
Yes.
Yes.
No, I have received just now. I received.
Yes. We will see just now. 10 it's communication of yesterday.
The last paragraph is important. The chief engineer PWD B Assam has requested to take necessary steps for preparation of standard design plan for public toilet facilities across court complexes by communication number so dated 28/8/2024. Subsequently, additional chief engineer PWD B Assam has informed that a model drawing of public toilet block has been prepared, including male, female, transgender, and differently abled persons with running water facilities. An estimate for the same has been prepared and submitted for approval of the Honorable High Court by communication number so dated 3rd of September 2024. The model design of public toilet complexes like F.
Last page.
Last. Like two and a half.
Last page, it.
All right, so you examine it. Mr.
Minor. Just now I have received it.
And what about the other states?
Look, so far as Assam is concerned, Milord, we have given also a report. It contains the initial affidavit by the government, thereafter our report, then the subsequent affidavit filed by the government. In the last page of that report, Milord, there are some.
Which report? This one?
No, Milord, there is another one. In the last page of that report, Milord, there are some remarks. Oh,
Yes.
these are to be looked into, Milord.
Which
In
remarks?
last page, page 18, Milord, backside it will be like. I'm sorry, Milord.
Yes.
Government may expedite allotment handing over process of land in respect of district judiciaries of Bishwanath, Choraidev, Dibrugarh, Dima Hasao, Jorhat, Shibosagar, Tinsukia, West Karbi Anglong, South Salmara, Karimganj, Bozali, and Nagaon. Here, my lord, the allotment and handing over process of land is under process in the initial affidavit and in the subsequent affidavit also. This has to be expedited. Second is that in respect of all the districts where plan and estimate for construction, renovation of the court buildings and residential quarters are already prepared, the government may be directed to expedite the necessary administrative approval and financial approval so that the construction of the works project may be initiated immediately. While getting administrative approval and financial approval, there is a halt in the process. So this has to be taken care of so that the administrative approval and financial approval are immediately procured. Then 3 is new projects which are covered under centrally sponsored scheme may be given top priority. Special mention may be made for immediate undertaking and completion of new projects related to the court building and residential quarters in respect of Bishwanath, Gopur, Dibrugarh, Naharkotia, Dhubri, Jorhat, Titapur, Hojai, Sankardev, Sonitpur, Hailakandi, Kachar, Karbi Anglong, and Karimganj. These are all centrally sponsored projects, my lord. There is hardly much involvement of state fund into this. So here there should not be any delay in implementation of the constructions and projects, my lord. Also, a timeline may be fixed in respect of preparation of plan and estimate by the district level PWD authority, counter signature verification by the respective district judge, and approval by the office of the chief engineer. Lord, the things are delayed in the process. So, and last one is with regard to CGM court complex, for shifting, because a new tender has been floated for shifting of the CGM building, but the existing building, condition is very pathetic. PWD has already issued a certificate that is not, that the building is not usable, but even then the court is, some repairing work is required there, my lord. That has to be looked into, my lord. These are basically, my lord, instead of giving details of each district, my lord, we have covered in some points that what are to be adhered to or what are to be, my lord, done in respect of district wise, that, my lord, we tried to place before your lordship.
When is the CGM office likely to be shifted in the new premise?
It will take 1 year as per the NIT.
As per NIT, for the 1 year, that will get allotted.
1 year.
1 year.
Because the existing revenue court building, it will be shifted there, and as per the NIT,
Police commission.
police commissioner building. So as per the NIT, my lord, the time limit is 1 year for entire renovation of the building as well as remodeling of the building for functioning of the court.
It was supposed to be done by end of October, November.
Yes, I also heard that.
1 year is not acceptable.
Yes, sir.
Open building,
No.
renovation.
Commissioner into office.
Please place those things in the record of this case. 1 year cannot be given for that. This is going on since last 2 years.
Yes.
Yes, Nagaland, you wanted to say something.
But in the last occasion, on filing our affidavit and placing before the court, where 5% of construction has been completed in ancillary. My lord has observed that we have to file an affidavit when the council has said that there is a crunch of funds. We have received some instruction, my lord. And on consultation with the Advocate General, he opines that it is not enough. So we will need some more time. In fact, he is there in Kohima today, and he's going to call the concerned member for a meeting and have a proper deliberation. And then we'd like to file a concise affidavit before your lordship, my lord. So I pray for some 3 weeks time.
Order was passed on 2nd of August.
Lordship.
Then we'll ask
We have received the instruction just
we'll ask the chief secretary to come.
today, my lord. They're having a meeting today and deliberation will happen, and then we will definitely file a concise affidavit for your lordship. we have received some instruction, which is not enough. So far as the new High Court building is concerned, 98% of the work has been done. That is what is recorded, my lord.
So what is your instruction?
Instruction they have given some, but my lord, this is not enough, saying that so far as the fund is concerned, because the state government only is funding, we have not received any fund from the center also, like unlike the other states, my lord. So the government is trying to work out to also complete the thing, the construction, my lord. But the instruction that we receive here is not enough, and therefore.
The Secretary Law and Justice in Government of India and ask whether this is how they propose to handle things.
My lord, we are in contact with the law secretary, my lord.
Take some strong measures now.
Lordship, we are in fact,
Too much. Can somebody look for Mr. RKD Chaudhary? Yes. See if he's around. We'll ask him to seek instruction and tell us what is the stand of the Government of India.
my lord, if your lordship would be pleased to give.
The government is not coming clean.
Lordship, in fact, we are also very happy that your lordship is taking step on this and trying to bring them.
We are happy means who is happy?
We are happy.
You are happy.
Yes, my lord.
And who else?
And everyone, all the advocates and all
And
the,
who is unhappy? Tell us that.
no one is unhappy for your interference in
Nobody
this.
is
We are
doing
very happy, but
Nobody is doing anything.
yes, that is why, my lord, as I said, my lord, we have received, but which is not enough. So I pray for some time, my lord. In fact, they will be sitting today and work will happen, and then we'll try to file a concise affidavit. If your lordship will be pleased to give us 3 weeks' time, my lord.
What about Arunachal, Mr. Joseph?
Obliged.
There were three issues, my lord.
Any further
Primary.
development?
Further development, my lord, actually, following your lordship's last direction to the amicus, my lord. So we are awaiting, he was directed to go through it and then give his opinion. But we are ready to give up-to-date status, my lord, that will get, and things are proceeding.
So far as Arunachal is concerned, we have filed a report. In this report, my lord, other things are all right, but serial number 5 with regard to Anini, Lord, there is some observation, my lord. Lordship will kindly have a look at the report, my lord. It says, my lord, if I may can read, my lord. Additional information, the court at Anini is functioning in a court building handed over by the district administration. The building is in a dilapidated condition and lacks basic security features such as iron grills in windows, etc. The building requires extensive renovation. JMFC Anini has been temporarily accommodated in a government quarter owned by Education Department. Then additional information 2, White notification number 11/10/2023, 5 Secretary District Legal Service Authority were posted at Upia, Teju, Khonsa, Bomdila, Pasighat. However, they have not been provided residence or office. In this regard, the Secretary DLSA Bomdila White letter dated 10/11/23 and the Secretary DLSA Upia White letter dated 18/3/24 have requested to provide residence and office. So this has to be looked into, my lord.
All right, anything about Mizoram?
Mizoram is all right. এইটো আপোনালোকে ৰিপৰ্টে ফাইল কৰে
Take down.
এইখনৰ এই ৰিপৰ্টখনৰ
ওপৰত গোটেইখিনি report যোন আছে, হা?
পিছত আমি ৰিপৰ্টখন ফাইল কৰিছোঁ কিয় নিদিম
In terms of our last order dated 2/8/2024, Mr. H.K. Das, learned amicus curiae, has examined the affidavits submitted on behalf of the state of Assam and prepared a consolidated report with parawise comments, which is taken on record today. The report in its concluding part has also made certain remarks in the form of suggestions which are reproduced herein below. Okay. Mr. D. Majumdar, learned senior additional advocate general Assam, has also submitted on instruction that information has called for
this is with regard to CGM Kamrup Millot, the shifting
by this court pertaining to the status of judicial infrastructure in the state of Assam has been received from as many as 13 districts, but the remaining 22 districts are yet to respond. Mr. Majumdar further submits that in terms of the order passed by this court on 2/8/2024, a standard design and plan for construction of public toilets for all the court complexes have been prepared under the supervision of the Chief Engineer, PWD Assam, and the same is now required to be approved for implementation with modifications, with minor modifications wherever called for. First of all, submitting that both the processes as mentioned above would require another 6 weeks' time. Mr. Majumdar has prayed for posting this matter again after 6 weeks, so as to enable him to file a consolidated report indicating the status of judicial structure, ongoing projects in all the districts in the state of Assam. Stop. Miss ये आओ learned additional advocate general Nagaland has appeared and submits that the affidavit in terms of the order dated 2/8/2024 passed by this court would not be filed since complete instructions have not yet been received. However, according to Ms. Howe, a high-level meeting on the ages of the Advocate General of State of Nagaland is being held in a day or two so as to find a solution to the problems facing the construction of ancillary buildings and structures in the newly constructed High Court building. Materials available on record indicates that the main building of the Nagaland Kohima bench of the Guwahati High Court had been constructed and completed long back, but due to non-availability of funds, neither the contractor has been paid his dues, as a result of which some finishing work of the building is still remaining pending, but there has been practically no work with regard to the ancillary buildings and structures which will be necessary for operating the High Court from the new premises. As a matter of fact, it is the admitted position that only 5% of construction has taken place in today with regard to the ancillary buildings and structures, including the residential accommodations as well as accommodation for the supporting staff. Question. Time and again, the only answer given to the court by the Council for the State of Nagaland is that due to paucity of funds, no further work is happening in the said project. Question. It has been brought to the notice of this court that due to failure on the part of the state government to complete the construction work of the new High Court building at Kohima, not only is the existing structure suffering decay and damages with the efflux of time, but there is huge cost escalation in the project, which the government of Nagaland is reluctant to bear, is apparently reluctant to bear, citing the ground of cost escalation system. Moreover, due to non-execution of the work of ancillary building and structure, the existing High Court, existing structure of the new High Court building has not been put into use, thus depriving the stakeholders from the benefit of such infrastructure, which has remained half done for nearly half a decade. Since the only stand taken by the state of Nagaland is that due to lack of funds, no further construction work is possible. We are of the view that there is a stalemate in the matter which requires to be resolved immediately, as otherwise not only will the institution suffer immensely, but even the infrastructure set up so far would be in serious danger of being damaged and wasted. Situated thus, this court is left with no option but to obtain the views of the Department of Justice, Government of India, seeking suggestions as to whether there is any alternative way out of this stalemate so as to facilitate early completion and inauguration of the new High Court building, which will be in the interest of the litigants as well as the members of the judicial institution as well as the bar system. We therefore implead the Secretary to the Government of India, Department of Justice, New Delhi, as a respondent in this case. Mr. R.K.D. Chaudhary, learned Deputy Solicitor General of India, is requested to accept notice on behalf of the newly impleaded respondent and obtain instruction. A copy of this order will be furnished to Mr. R.K.D. Chaudhary within 2 days from today. Insofar as the state of Arunachal Pradesh and Mizoram is concerned, the learners amicus curiae has submitted that the affidavits filed on behalf of the aforesaid two states are under scrutiny, and as and when more inputs are received, a report on that behalf will be placed on record. Taking note of the submissions of learned counsel for both the sides, let this matter be listed again on 1st October 2024, only for the purpose of considering the action required to be taken for completion of the High Court, new High Court building complex at Kohima, on or before the next date, Ms. so-and-so learned additional AG shall positively file the affidavit on behalf of the state with complete instruction, failing which this court will consider directing personal appearance of the Chief Secretary of Government of Nagaland to answer the queries of this court. Mr. R.K.D. Chaudhary to also obtain instruction and appraise this, it will be already yours. For considering all other issues involved in this proceeding, this matter will be listed. On 4th of November. 4th of November 2024. In the meantime, a complete action taken report on behalf of the state of Assam, as well as the response of the learned amicus curiae with regard to such report shall be placed on record. Mr. Chaudhary, this drama has to now end. Okay. Have you visited Kohima?
Yes,
Have you
Lordship.
been there? Have you seen
Yes.
the new building?
Yes, Lordship.
10 years back, this building was constructed.
Lordship.
It's a massive building. The conference hall for a high court, which is supposed to have 5 or 6 judges, is bigger than 1 floor of this high court. This is the enormity of the building. Already 100 crores has been spent by the contractor. But he has not been paid even 30% of his bill, as reported. We don't know. Several attempts on the part of the Honorable Chief Justice, the building committee, the portfolio judge, requesting the government to do something about it has ended in failure. The state government is only saying we don't have money. The ancillary work is not being even started properly, so that building cannot be made operational. Without the supporting staff, you can't run it. Now, this is a stalemate which can go on. These buildings are required to be inaugurated. The High Court should start functioning from there. That is where the interest of the society, the litigants, everybody lies. So now a time has come when we have to take some drastic steps. What is the stand of the Government of India Department of Justice? We want to know it on the next day.
Lordship.
So we have implemented the secretary. You tell us. This is not about any confronters attitude.
Yes, I do understand.
Tell us whether you can arrange for some funds if necessary from the donor ministry or anywhere. And we will take over the construction. We'll not let Government of Nagaland play any role here.
Lordship.
And we'll create a special SPV. We'll create a special purpose vehicle to see that this work is completed without absolving the state of Nagaland of its liabilities.
Lordship.
That's what we are thinking. If they are only saying they don't have fund, which may or may not be genuine, we'll not go into that. That is a matter to be verified at some other level. We are only interested in ensuring that the building is completed.
Lordship.
The court building is inaugurated and it starts functioning from the new building. We want to do it in a time-bound manner. The fund is the only issue. By a
That has to be
judicial fiat,
arranged.
we'll take over the matter from the state.
Lordship.
We'll not let the state get involved anymore. Can you talk to the concerned authorities and
Yes, Lord.
tell us if some 40-50 crores can be earmarked, maybe outsourced or diverted from say donor ministry or anywhere, because this is a institute of public importance.
Lordship, I will.
Then what do you do with the massive high court structure? It is soon going to become the abode of all
And-
these wild creatures and nobody will be there and it will be wasted. Another 50-60 crores will be required to need to repair and
Yes,
renovate
as time
a
goes by.
building which has not even been put to use.
Lordship.
This is atrocious. This is completely, it's very sad. But whoever is responsible, whatever is the story, we are not interested. It is not our job. Let the departments and governments figure.
The infrastructure has to be there.
We are
first.
only interested in completion of the infrastructure.
I
Can the government of India play some role in this?
I will definitely impress upon the concerned
And
authority.
we
Lordship.
would like to go by this suggestion of the government of India
Yes, yes.
instead of, because these are financial matters. For a mighty government of India, I don't think arranging for 50-60 crores will be a very big problem. They can recover it.
Yes.
Let them deduct it from the grant in aid given to the Nagaland, state of Nagaland. We'll
Gosh.
provide for that in a judicial order.
Lordship.
And
Gosh.
let them examine the bona fide of the stand. If they are not willing to give the money, why should we prod them? We'll find out other ways and means of doing it.
Yes, Lordship.
So the order we are proposing to pass was after hearing them, and you may also please communicate to your government. We may pass an order asking the law ministry to provide for the fund and recover it from the state by deducting from the granting aid or from the GST apportionment. We'll provide for that. Then you sort it out with the government of India. And we will also remove you from the entire process of construction. Ask the CPWD to carry out the construction, and there will be no credit for the state government. Things must come to an end. We have had enough. Enough has been done. Enough requests have been made. If the authorities are not willing to relent, there are other ways and means. We'll do it. It's a question of High Court building, so therefore we will be well within our means, jurisdiction and authority to figure out ways and means to complete the construction. We are not asking anyone to construct a High Court. All we are asking is complete it. You have started it, you have constructed, you have put in 100 crore rupees, complete it. That's all we are asking. For a state government, 30, 40, 50 crores is becoming such a big problem. Or is there any other issue, any other latent issue? We don't know. But we are not interested. And as it is, the reports are saying that the cooperation is not coming from the state in these matters. That is another matter. We will not go into it right now.
Lordship,
Have you understood the mandate?
Lordship, in fact, there, I have appeared in some cases, there are some litigations. I'm aware of that, Lordship.
Litigations regarding what?
So far as the construction and the contractors are concerned, Lordship, some,
No,
but that is another aspect of the matter. This
Is there a stay order of
No.
construction?
No,
Then
it's not on that, it's regarding the contractors and
that is, we are not
That's-
concerned with that. If the contractor doesn't work, we'll have another contractor do it. But the building has to be complete.
yes.
And it has to be inaugurated.
Yes, Lordship.
The High Court has to be made functional from that building. Because that is why the construction was started.
Yes,
That is the
Lordship.
aspiration of the people. That is what the lawyers want. That is what the judiciary wants, the registry wants, the litigants want.
Lordship.
What is the point in keeping it hanging like this after 10 years? So for all other purposes, it will come on 4th. Only for this purpose, it will be on 1st October.
Supplementary.
Much
list,
in this.
supplementary.
May praise the Lord. Lordship, I am appearing in item number 3.
What are these items?
Lordship, these petitioners are non.
These matters have already been heard.
Lordship, these are under the 2018 Act, the non-teaching provincialization of non-teaching staff of venture education institution. The 2017 Act was of the teaching staff, Lordship. And 2018 Act, Lordship, herein the petitioners are non-teaching staff. Lordship, we are aggrieved by the fact that, Lordship, irrespective of qualification, everyone provincialized under the 2018 non-teaching staff have been granted fixed pay. And there is no provision, unlike the 2017 Act, that for acquiring certain qualifications or something, a regular scale will be granted. They have no opportunity at any point of time in their entire service career to get a regular pay scale. The qualifications are same as that of state government employees for 4th grade staff, non-teaching staff. Yet they have been granted only a fixed pay. We are aggrieved by that, and therefore we have preferred this writ petition. The matters may be taken up for hearing, fixed for hearing.
Had learned counsel for the allegations. All these are same matters. 2 to 5.
I'm on item number 2 and 2, 4 and 5.
2, 4 and 5. And
Yes.
you are for number 3. So all these are similar.
Yes, my lord.
Okay, common order there, 2 to 5.
Okay.
In these petitions. provisions of section 4, bracket numerical 1, comma, 6, bracket numerical 2, bracket numerical 2, bracket numerical 4, and bracket numerical 2, 3, 4, bracket of the, what is the name of the act?
Yes.
Assam Education, bracket provincialization of.
Assam Education Provincialization of Services of Non-Teaching Staff of Venture Educational Institutions Act 2018.
Institutions, bracket close Act 2018 have been put under challenge. Mr. Katonier, Learned Standing Council Education Department has appeared for the respondent and submits that since legal issues are involved in these writ petitions, the matter has been admitted and posted for final hearing. Now, this case has been admitted.
Yes, madam.
Matter has been posted for final hearing. The Learned Council for the petitioners has also agreed to the same suggestion. In view of the above, let these writ petitions be listed for final hearing in the second week of November 2020.
My lord, kindly fix and date, my lord.
Second week of November.
Second week?
Issue rule issue rule returnable on 13th of November 2020. Since the official respondents are already represented, no formal notice of record in this cases. Parties to exchange pleadings in the meantime, it's a request.
Listing out this matter, Lordship, in the next week or the last week of this month, Lordship. Lordship, I am required to produce some of the judgment, Lordship. It's a case of parallel proceeding. So. Lordship,
You are for the petitioner?
No, for the government, Lordship.
May I please, Lordship? Lordship, I beg to mention item number 20, Lordship, with the consent of the other side, I beg to, Lordship, for adjournment for the day, Lordship.
You have taken the consent of
Yes,
other side.
Lordship.
On the request of Ms. R. Devil and CDC made with the consent of the other side, admission hearing of this matter stands adjourned for 2 weeks.
But I beg to mention item number 41, my lord. The quantum matter that had become infectious.
Item 41.
41.
Mr. F. Hawk, Learned Counsel for the petitioner submits that the order of this court has already been complied with, and therefore the contempt case has become infectious. In view of the above, the contempt case stands disposed of as infectious. IS stands closed.
May it please your lordship. Lordship, I beg to mention item 6, lordship. If this matter be taken up any other day, lordship.
In the prayer of petitioner's counsel, this matter stands passed over for the day. Please.
May please, your lordship. Lordship, with regard to item number 48, an appeal has been filed, your lordship, and the single bench order has been stayed, your lordship.
You are appearing for whom?
I'm for the petitioner, your lordship.
I appear for the respondent number 1.
Begin.
Your name, please?
S. Gautam, your lordship.
Mr. S. Gautam, Learned Counsel for the petitioner submits that in an appeal preferred against the judgment and order of the learned single judge, the division bench has stayed the operation of the order and therefore consideration of the contempt case is adjourned, awaiting final disposal of the appeal. Mr. A. Das, Learned Counsel for the respondent number
1, your lord.
1 is present and does not have any objection to the prayer. In view of the above, this matter stands adjourned for 8 weeks, awaiting the outcome of writ appeal number.
I provide the lord.
Writ appeal number so and so. Yes.
Oblige, your lordship.
Oblige, your lord.
May it be your lordship, I beg to mention item number 9, your lordship. May it be taken after this
In the
week.
prayer of petitioner's counsel, this matter stands passed over for the day.
Oblige, your lordship.
I beg to mention for listing admission for my pension matter, family pension matter.
Next week.
May it please your lordship, with the consent of the other side, I beg to mention item number 23 to 25, lordship. In this matter, we have to file an affidavit, lordship, in reply that has been sent for vetting, lordship.
You are appearing for whom?
For the petitioner, lordship. We have taken the consent of the other side.
Your name, please?
R. Deka, lordship.
Mr. R. Dekal and a counsel appearing on behalf of the writ petitioners in this batch of writ petitions submits that his clients are in the process of filing a rejoinder affidavit.
Yes, lordship.
And therefore 3 weeks time be granted for the same. The prayer is not opposed by the respondents' counsel.
Lordship, there is an interim order that may.
In view of the above, these matters stand adjourned for 3 weeks. Interim order passed earlier to continue
Much of.
until further orders. 23 to 32.
May I please, your lordship? I beg to mention item number 4.
Yes.
With the consent of the other side, adjourn for the day, your lordship.
On the prayer of learned counsel for the petitioner, this matter stands passed over for a week.
Bless.
Mainly this for motion item 1.
May it please your lordship. My lord, this contempt petition actually was for non-compliance of order dated 18/1/2024 passed in WPC 3260 of 23. This matter came up earlier before this honorable court on 2nd August, on which date, my lord, there was my lord, a query by this honorable court as to whether there was a representation by the petitioner communicating the order of which non-compliance has been alleged and contempt has been filed. Now, I verified from the petitioner. Now, here, we have filed an additional affidavit bringing on record the fact that representation before the filing of the contempt petition was not preferred by the petitioner. That we have brought on record by way of an additional affidavit. But what we are contending here is, because of the fact that the order contained twofold directions. One was for payment of family pension and the other was for release of the arrear pension, and both of which were undertaken by the respondents. It was not that it was decided on contest. It was undertaken by the respondents, which your lordship will see in the contempt petition at page 19. If your lordship...
Mr. Chakraborty, you have two options here.
My lord.
Either to get a dismissal later on or withdraw it now and comply with. It is a contempt case, you can demand compliance of the
I
court
understand, my lord. I'll
order.
prefer
Do
to.
it. Why? What is the point in going here and there?
My lord, that's
On
why
the
I
request
brought
of
on
Mr. D. Chakraborty and counsel for the petitioner, this contempt case is closed on withdrawal with liberty to the petitioner to demand compliance of the order passed by this court before approaching.
Deeply obliged. Deeply obliged.
Register to list this case again in the next week by reflecting the name of learned counsel for the petitioner in the cause list.
May to the lordship. The result of the petitioner was withheld in this case, in the SSC case, lordship. So, advertisement was of the year 2021, and result was on 7/11/2022. In the result, the name of the petitioner did not come. There was another list of withheld candidates where the petitioner's name was reflected. Petitioner's roll number was reflected. So he inquired and found that during his medical examination, before some days of his medical examination, his left thumb was burned. And according
what was burned?
Left thumb. So when the thumb impression was taken, the left thumb impression did not come properly. But the authority took his signature in 70 pages to compare it with his CBE card, lordship. So after the examination was over, result declared by the petitioner's CBE card was not sent for forensic examination. So he submitted RTI application before the authority, and he came to know that the Assam Rifles Authority, they have requested the page 64, lordship, may kindly see once.
You have got instruction.
No, lordship,
Several adjournments.
Assam Rifles is impleaded on the last occasion.
Then we'll have to issue notice and
Yes,
decide
lordship.
it. What is the point in, what can be done today?
Lordship, what I said.
Allow the writ petition.
No, no.
Then what can be done?
Notice will be issued, lordship.
Within some time frame, because the result was published in.
Mr. Harshamal, counsel for the
2022.
petitioner hearing had participated in the selection process conducted by the respondents for appointment in the post of constable GD. However, despite doing well in the examination, the petitioner has not been issued appointment on some technical grounds which were not properly explained, which according to the petitioner's counsel has not been properly explained by the authorities. Hence this writ petition. First, Ms. R. Devi, learned CGC appearing for the respondents, pray for some more time to obtain instruction in the matter. Issue notice returnable in 4 weeks. Since the learned CGC has appeared and accepted notice for all the respondents, no comment, including the newly implemented respondent number. Have you filed a amended cost title?
Yes, Lordship, I have furnished extra copy of the petition also to.
Have you filed an
Yes,
amended
Lordship, I have already
cost title?
filed.
This is not there on the record? When did you file the amended cost
It
title?
was on 20th of August, Lordship.
Including the newly implemented respondent number 9. Hence, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisite numbers be furnished to Ms. Devi, learned CGC, so as to enable her to obtain instruction facilitating disposal of the writ petition at the stage of admission hearing.
Yes, sir.
We'll finish it off next day.
Problem.
May it please your lordship. Lordship, the matter is related to pensionary benefits, your lordship. The petitioner is working as a junior engineer in ESCB, my lord. And after that, my lord, he has passed an application for voluntary retirement in the year 1995, my lord. My lord, then he has also filed a writ
So
petition.
here
that
also
is-
notice has to go.
Perhaps a short notice would do, my lord, because it seems pensionary benefits are due from 2011.
My lord, my lord, it's due from,
Sometime next week, my lord, I'll get the instructions.
given direction to pay the benefit, my
Alright,
lord, to 15 years, my lord.
Ms. T. Box, ST Box, counsel for the writ petitioner. Where is the amendments made in the writ petition? The petitioner is aggrieved due to non-payment of pension, although he is entitled under the rules to receive the same. Mr.
B. Chaudhary.
B. Chaudhary, non-standing counsel,
APDCL.
PDCL, seeks posting of this matter again in the next week so as to enable him to obtain instruction. Facilitating disposal of the, facilitating early disposal of the writ petition. Mr. J.K. Goswami, learned additional senior government advocate, Assam, is present on behalf of the state. On the state respondent number 1, on the request of the learned counsel for the APDCL, this matter is directed to be posted again in the next week for motion. 2 extra copies be furnished to Mr. Chaudhary so as to enable it for instruction.
Obliged, your lordship.
I can say that.
Deeply obliged.
May I please, your lordship? Lordship, in this case, I am challenging the dismissal order but at page 75 and as well as for the appellate order at page 108. Millard. What happened, Millard? While working in the as a LDM, he was dismissed pursuant to the disciplinary service, Millard. And lordship will.
The dismissal order is 28/12/2000.
Lordship.
And
Appellate order
is 23rd April 2000.
Lordship.
Will issue notice.
Lordship.
Or Mr. M. Mantal and counsel for the petition. There is the amendments made in the writ petition. By filing the present petition, the order of dismissal from service dated 20th/12/2012, as well as the taking order dated 24/4/2024, rejecting the appeal preferred by the petitioner, has been put under challenge. Mr. R. Dhar, learned standing counsel, PWD, Assam, prays for some time to
All the
instruction and file affidavit. Issue notice returnable in 6 weeks. Since Mr. Dhar has appeared and accepted notice for all the respondents, no formal notice, extra copies, etc., etc.
My lord, the grievance here is non-inclusion of the names of these petitioners in the list that was prepared for being covered under the old pension scheme. Initially, my lord, page 37.
So notice has to go in this.
Notice
case.
has to go.
I heard Mr. B. Patak, counsel for the petitioner. The writ petitioners herein claim to be entitled to the benefit of the old pension scheme. They are agreed due to non-inclusion of their names in the list of beneficiaries identified by the authorities for conferment of the benefit of old pension scheme. Mr. Patak submits that this is a fit case where a writ of mandamus lies. Mr. G. Pegul and CGC appearing for the respondents, however, prays for some time to obtain instruction. Issue notice and motion returnable in 6 weeks. Since Mr. Pegu has accepted notice No formal notice is required to be sent in this case. Extra copy of the writ petition, requisiting numbers, be furnished to Mr. Ahmed. Thank you so as to enable him to obtain instruction.
Made his lordship. My lord, the petition here is praying for retention of general pool accommodation by the first class 1 officer of all India service cadre. The petitioner here are officers serving in border security force. Presently, the petitioner are posted at a non-family station, that is Thupri, Assam, West Garo Hills, Meghalaya, and Silchar, Assam. The prayer of the petitioner here is to allow the dependent family to continue for the accommodation in the last posting place. This is the prayer.
Last posting place is where?
It's in Delhi, my lord.
Lordship, they are challenging a memorandum whereby that facilities were withdrawn, Lordship.
Where is that memorandum page?
Annexed 10,
Page number.
Page number
page number
97.
97, my lord.
So is there a stay order?
Yes, my lord, there are
They have
pending
stated
cases.
some cases are pending.
Out there, there is a stay order is there, no course of action be taken.
WPC 925/23 and some similar cases.
Where similar order, show me?
Similar orders not here, Lordship.
Your name, please?
Tiwa Pangla.
This so and so counsel for the writ petitioner. Also heard Ms. B. Sharma, Learned CGC appearing for the respondents. The writ petitioner hearing who is serving as who is a class 1 officer of All India Service, presently posted as
My lord, second commandant.
second commandant in the CRPF.
BSF. Lord.
BSF, my lord.
BSF at which place?
Three petitioners are different places.
Achha. The 3 petitioners who are members of the class 1 All India Services serving under the Border Security Force are presently posted at various locations in the state of Assam, which are considered to be non-family locations.
One is Meghalaya also. Petitioner number 2 in Meghalaya.
Assam and Meghalaya, Meghalaya, which are considered as non-family states. Prior to their posting in the northeastern India, they were occupying quarters. They were posted at Delhi and occupying residential quarters. Full stop. As per the prevailing policy, such officers were allowed to retain the residential quarters for their family members in the previous place of posting, which in this case is in New Delhi.
My lord.
However, in the wake of the notification dated 6/10/2022 issued by the Deputy Director of Estate Policy, Government of India, Ministry of Housing and Urban Affairs, the said policy has now been withdrawn. First up, the petitioners have approached this court apprehending eviction of their family members from the residential quarters under their occupation. First up, occupation in New Delhi. First up, Ms. So-and-so submits that similar writ petitions are pending before this court where an interim order has been passed. First up, Ms. Sharma has also confirmed the said position. In view of the above and with a view to maintain uniformity in judicial order, This court is of the view that the matter calls for examination. Stop. Issue notice returnable in 6 weeks. Since Ms. Sharma has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers be served upon Ms. Sharma within a week from today so as to enable her to obtain instruction. Let this matter be listed again along with WPC number 2979 of 2023, heard on the prayer of interim relief. As an interim measure, it is hereby provided that no coercive action will be initiated against any of the petitioners or their family members for their eviction from the residential quarters under their occupation until the returnable date.
May it please your lordship. My lord, petitioner is serving in Assam Rifle. He is almost completed 17 years of service, my lord. He is aggrieved by the action of the respondent authority, my lord, because in 2 occasions, my lord, without hearing him, my lord, without following the rule, my lord, he has been given, my lord, reading entries, my lord. So, my lord, I had this says praying for a notice, my lord. I have annexed the rule also. They have violated the rule.
What Mrs. Boral on counsel for the petitioner. The read petitioner hearing is serving under the Assam Rifles system, being aggrieved by insertion of 2 reading entries in his SCR. The instant read petition has been filed inter alia contending that the respondents have put the reading entries in violation of the rules, thus causing serious prejudice to the interest of the petitioner. Mr.
K. Vishwakarma,
K. Vishwakarma.
on behalf of Mr. S.P. Chaudhary,
No, but who's
for
this?
Union of India. Madam.
Are you in the panel?
Yes, madam.
Mr. S.P. Chaudhary, Rana CGC, has appeared and accepted notice for all the respondents. As such, no formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to the learned CGC so as to enable him to obtain instruction. Let the matter be listed for admission again after the notice is 6 weeks, huh? 6 weeks.
I oblige.
Item.
My lord, in this case, my lord, petitioner paying, my lord, financial obligation under MSCPS scheme, my lord.
The writ petitioner hearing is aggrieved due to non-consideration of his case for financial upgradation by conferring him the benefit of ACP stroke MSCP scheme. Mr. Heard, Mr. K. Kalita,
Yes.
learned counsel appearing for the writ petitioner. Miss, you are appearing for?
Transport Department, 1, 3, and 4.
Miss M.D. Boral, Understanding Council, Transport Department, Assam. Prays for some time to obtain instruction in the matter. Issue notice returnable in 6 weeks. Since Ms. Bora has appeared and accepted notice on behalf of
1, 3, and 4.
1, 3, and 4, and Mr. Who is Finance, Government of Assam, and Mr. H. Olia, Understanding Council, Finance Department, Government of Assam, for respond number 2, service of notice deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the Learned Departmental Council so as to enable them to obtain instruction. Register to list this case again by reflecting the name of Learned Standing Council for the respondents in the cause list.
Duty of license.
Item 13.
May I please, Lordship? My lord, the petitioner, my lord, before Lordship, my lord, he was dismissed from service, my lord. And he was a SSB constable. And 3 charges were leveled against him, my lord. And the authority concerned, my lord, without following the procedural rules, my lord, he has been dismissed from service. And my lord, your Lordship will find the
But you have written,
dismissal order.
he's resigned from service on 3-5.
No, my lord.
Your synopsis says so. You are in item number?
14, 1-4.
Then you wait, you are in 13 now.
Sorry, my.
Wait, leadership, 13.
You have resigned.
I am forced to resign, my lord. That's why I am before your
No,
lordship.
but you have resigned.
Yes, my lord.
Now what do you want?
Now, my lord, forced to resign, my lord, it is not
You want
voluntary.
the court to force them to take you back.
Yes, my lord, this unfair treatment at the work compelled me to resign, my lord. And there, Thereby I had come before this honorable court.
But this is a private company.
No, it is public limited company.
Public limited company, you are mistaken. Public limited company is not a public authority. Do you know what is a public limited company?
My lord,
Are you aware or not? Tell me.
my lord, I'm
You,
something
you
I-
don't. Because you thought public limited company is a public sector undertaking.
My lord, as per
You must,
company
as a
Act-
lawyer, you have to study sometimes.
Company Act, my lord, 617, section
Hmm.
617.
Hmm.
It defines that is the public.
Reliance Limited is also a public limited company. You know that.
Yes, my lord.
Why is it?
Because my lord, regarding share capital,
This is not maintainable. Check the law. We'll dismiss it on Friday. List again on Friday. So as to annul petitions. A public limited company is a company which is more than 2 members. Check up the law. It is not a public authority. It's a private company. You have to approve the relevant forum, not read petition.
Item 14.
May I please, Lord?
Yes.
Lord, the petition was dismissed from service, my lord. Heights order dated 13/5/2022 at case
The order of
49.
dismissal from service by the order dated 13/5/2022. Not dismissal. Initially, it was compulsory retirement.
Yes, my lord. They awarded sentence of compulsory retirement from service. At page
By the order
49.
dated 21/7/2022 imposed by the appellate authority by converting the penalty of compulsory retirement from service awarded by the disciplinary authority by the order dated 13/5/2022 have been put under challenge in the present, has been put under challenge in the present petition, inter alia contending that the authorities have acted without jurisdiction and contrary to the relevant provisions of the Act. Full stop. This, they cannot do it.
Lordship.
We'll set aside this order.
Lordship.
What is this happening in your institution? He has preferred an appeal and you grant relief to some other party. The petitioner has preferred an appeal.
Lordship.
And in his appeal, you have enhanced this sentence.
Not enhanced, Lordship, it was compulsory retirement. Yes.
Compulsory retirement and dismissal are same.
Not dismissal, compulsory retirement, it was
That has been
uphold.
changed to dismissal.
This was, no, Lordship, it was uphold, page 55, Lordship.
But that's what he's saying.
No, Lordship. Appeal, dismissing the appeal and dated so-and-so, preferred by so-and-so, so-and-so being devoid of merit and uphold the punishment of compulsory retirement. Uphold the punishment only, Lordship.
So then, can you write again? The petitioner is aggrieved by the penalty of compulsory retirement from service awarded by the order dated 13/5/2022 and the rejection of his appeal by order dated 21/7/22 by the appellate authority. Heard Mr. S. A. Ahmed and counsel for the petitioner, peruse the amendments made in the writ petition, issue notice returnable in 6 weeks. Mr. S. S. Roy, Learned CGC appearing for the respondents has accepted notice for all the respondents. As such, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisite numbers be furnished to the learned department counsel so as to enable him to obtain instructions.
Oblige.
Item 15.
May it please your lordship.
Yes.
My lord, the petitioner has been appointed as the driver of Moiravari Fire and Emergency Service Station by order dated 26/11/2010, your lordship. That is at page 11, your lordship. So what happens is that, your lordship, pursuant to the FIR dated, FIR lost by my wife, your lordship. So eventually, this was culminated into your lordship.
Where is the penalty order to enable into?
Lordship is at page 18, may kindly be looked into, lordship. Page 18. 2 months, 2 annual increment, your lordship.
So there was an inquiry proceeding.
Lordship.
Then the charge has been found to be proved.
Yes, your lordship.
Thereafter, this annual increment.
But your lordship, whatever the, because the person to the FIR, your lordship, is a private dispute between the husband and wife, your lordship. And your lordship, he has been acquitted, your lordship.
No, that's right, but what are you challenging here?
I have challenged your lordship, page 18, your lordship. Page 18.
That you can't, because if the inquiry is maintainable, then the order will come. You have not challenged the inquiry proceeding.
I am not, because no appeal is filed, your lordship, before the government, your lordship.
You have either understood or there is no hope. I am saying you have submitted yourself to the inquiry, disciplinary inquiry.
Yes.
You have participated in the inquiry proceeding.
Lordship.
The inquiry officer found the charges proved.
Your lordship.
Then there was a penalty.
Lordship.
You are only challenging the penalty on the ground that there could not have been any inquiry because it is a private dispute. That you can't do. So we can either dismiss it today or after 6 years, it's all the same.
Lordship.
Little bit of knowledge of law is required to become a lawyer. Little bit, not much. You have submitted yourself to the inquiry proceeding. Why did you not raise it then that there cannot be a departmental inquiry on this?
Lordship.
So now or 6 years, after 6 years, which one? Dismissal now or after 6 years?
So liberty may kindly given you lordship to file.
Liberty to do what?
To,
Huh? No, you don't rush into,
lordship.
you examine it. Don't rush into where the court is not against your client or against you.
Lordship, then.
But whatever is legally permissible, you have to do it.
Lordship, my respectful submission before lordship, then 2 weeks time may kindly be given you lordship.
2 weeks time.
2 weeks time may
Bench will not change. This bench will not change in 2 weeks. 4 weeks, then there is a possibility. Why don't you find an answer to your client's problem by doing some research instead of running away from the bench?
Sometimes may kindly be allowed in lordship so that I can go into the lordship to verify in lordship as to what are the shortcomings out there in lordship.
Do it. That's the right approach.
Lordship.
We are not against your client or against you.
Lordship.
You are asking for something which is not legally permissible. If you have accepted the inquiry, and how can you now resist the penalty order saying that the inquiry was not maintainable? The request of Mr. Jiwan and counsel for the petition. This matter stays adjourned for 2 weeks so as to enable him to look into the legal issue and address the court. Find out, otherwise today or tomorrow the result will be the same.
Plus, take the instruction.
Order impeachment of party, item 16.
May it please your lordship. Lordship, according to order dated 29/7/2024, the impleadment of Department of Tribal Affairs and Department of Social Welfare and Employment, Government of Assam was supposed to be impleted. My lord, we have given them a copy also.
Lordship, we have received the copy. I am appearing on behalf of respondent number 3. Lordship, may I submit one thing?
Yes.
Lordship, the Assam Plain Tribes Development Corporation is not a necessary party. The petitioners were appointed by the WPT and BC department. So, Lordship, our name is to be strike off from the petition.
No, you want it to be impleaded.
Lordship, that is fine.
And after impleadment, you want
Yes,
to be struck off.
Yes, Lordship. No, Lordship, they are not impleading us. We are already a party in the petition.
Okay.
They are impleading some other parties. Social Justice and Empowerment Department.
Why they have to be impleaded? These two.
Lordship, now WPT department has divided into 2, your lordship. Our grievances with Department of Tribal Affairs, Plain and Social Welfare Department.
Earlier, they have impleaded us, but we are not a necessary party.
Heard Mr. S. Gautam, learned counsel for the applicant. Also heard
G. Swami.
Miss G. Swami, learned counsel appearing for the
Respondent number 3.
who is for 1 and 2?
I'm appearing for Social Justice and Empowerment Department for respondent number 4, newly impleaded party. Lordship, they have not served us the copy of the petition.
I have.
Social Justice and Empowerment Department.
Social justice.
No, no.
Miss, your
They
name
have not
please?
submitted.
G.
yeah.
Swami.
No.
Yes, Sir Lordship. Lordship, I am appearing for Social Justice and Empowerment
The
Department.
Lana Standing Council for
DG.
the Social Justice and Empowerment Department submits that she has not been served with a copy of the IA. In view of the above, a copy of the IA be served upon the Lana Standing Council. Let the matter be listed again after 10 days. You are for
Lordship, I am for our tribal affairs.
the Lana Standing Council Tribal Affairs Department. Have you received copy?
No, Lordship.
Standing Council of these and that both submit that they have not. Give them the copy.
Yes, Your Lordship. I'll let it.
We'll consider your prayer on the next day.
Next
Once they are impleted, you may be out.
May I please, Your Lordship. My lord, this matter relating to the pensionary benefit and the opposite party, my lord, has not been made a party, and during the proceeding, my lord, it come to notice that the, my lord, opposite party is the appropriate authority to disburse and compute the pension. So accordingly, my lord, I filed this application to implement.
Mr. M. Islam Nagaland Council has appeared for the applicant. This IA has been filed with a prayer to impede the Accountant General, bracket A&E, bracket Assam, Beltola, as a party respondent to the connected read petition. Primarily on account of the fact that the prayer made in the read petition is pertaining to grant of pensionary benefits. Mr. Islam submits that due to oversight, the opposite party was earlier not impeded as a party respondent to the read petition. Mr. R.K. Talukdar, Learned Standing Counsel for the AG A&E Assam, is present and does not have any objection if the prayer is allowed. So also is the stand of Mr. J.K. Goswami, Learned Additional Senior Government Advocate Assam, appearing for the state, and Miss.
5 and 6.
Huh? And Mr. S. Dhar, 5 and 6, and Mr.
5 and
S.
6.
For respondent number 1. The other respondents are not present. In view of the above, it is hereby ordered that the Accountant General A&E Assam, Beltola, be implemented as respondent number
10.
in the connected read petition. Applicants counsel to furnish amended cost title in the read petition. Let the read petition within a week. Let the read petition be listed thereafter for orders. I stand disposal.
Highly obliged, Your Lordship.
For admission, item 18 and 19.
Yeah, please, Your Lordship. My lord, case of the petitioner is, my lord, is removable from service for alleged misappropriation of 7,18,849 of the Assam Tea Corporation Limited. My lord. There was 2 proceedings against the petitioner, one departmental proceeding, one criminal proceeding. In the criminal proceeding, he was acquitted honorably, and departmental proceeding, he was awarded punishment of removal. Already he has crossed 60 years, my lord. Yes, last year.
So reinstatement is not possible.
No possible, not possible. That is why, my lord, I have alternative prayer for payment of money. What about the money entitled to? So as per their statement, my lord, they are.
So we'll have to hear the matter today.
Yes.
My
You are appearing for
vacation.
I am for the corporation, the Assam Tea Corporation, this one number.
After vacation.
Heard Mr. J. Shabar, counsel appearing for the read petition. I also heard Mr. M. Datta, counsel appearing for the respondent number.
My lord, 2, 3 and blood, that's 4 million.
I would always request the respondents counsel to at least be ready with who they are representing.
That's 2 million.
If a question is asked for the 3rd time, the councils don't even know.
2 million.
Respondent number 2. December serially arranged and
Item number 18, I'm for respondent number 3, and in item number 19, I'm for respondent number 5, Employees Provident Fund Office.
EPIF. Your miss.
It's
okay. So, Then you write learned additional senior government advocate Assam, Mr. M. Datta, learned counsel for the ATC, and Ms. H. Chakraborty, the counsel for the Employee State Provident Fund in both the cases. Full stop. Having heard the submissions made by learned counsel for both the sides, this court is the opinion that the matter would require detailed hearing. As such, admit the writ petitions. Since the parties are already represented, no further notice is required to be sent in these cases. Register to list this matter for final hearing after the ensuing Puja vacations on a non-miscellaneous day.
Well, plus the records will be necessary, perhaps. Sorry, also the records also.
The records of the departmental proceeding be kept ready for perusal by the court at this stage of hearing.
Item 21 and 22.
May please, Your Lordship. I will kindly peruse the last previous order, madam. 26/4/2023. So some instruction was supposed to be placed before the court.
Where is the Persons with Disabilities Equal Opportunity Protection Act? Persons with Disabilities bracket Equal Opportunity Protection of Rights and Full Participation Rules 1996. Yes, have you received instruction?
Here, Lordship, actually, social justice and empowerment department to be implemented, Lordship. Because social welfare department is two department now.
So and so for the petitioner, so and so.
Empowerment department.
So and so preparing for the Health and Family Welfare Department. It is submitted at the bar, heard so and so that the relief prayed for in the writ petition cannot be granted without hearing the social
Justice and Empowerment Department.
Social Justice and Empowerment Department of the Government of Assam. But the said department is not a party to this proceeding. After taking note of the submissions made at the bar, the Secretary to the Government of Assam, Social Justice and Empowerment Department is hereby impleaded as respond number.
It will be 9, madam.
Respond number 9 in the connected writ petition. Miss
D. Jane.
D. Jane, Learned Counsel.
Lordship, I'm appearing on behalf of Mr. R.M. Das.
Mr.
Standing R.M. Das.
Now we'll record his name.
Yes, sir.
Mr. R.M. Das, Learned Standing Counsel, so and so department is present. On behalf of the so and so department, on behalf of the department, and assures this court that necessary instructions will be obtained by him by the next date fixed. The petitioner's counsel to file an amended cost title within a week from today. The Learned Standing Counsel of the newly implemented respond number 9 to obtain instruction.
Oblige, sir.
My lord is fixing a date, madam.
In terms of the order date, what is the date of the previous order?
Previous order was passed on 26/4/2023.
In terms of the order dated 26/4/2023.
23.
Passed by this court. Let the matter be listed immediately after the ensuing puja vacation.
It will get me fixed, madam.
Immediately means immediately.
Both orders will go for both the petitions.
Both the
Okay.
petitions.
Well, there is interim order in both the
Interim order passed earlier to continue until further order.
I'm deeply obliged.
Item 26.
It's all adjourned.
May it please, my lord, the petitioner before lordship, my lord, the SLC, my lord, considered him, but he could not be accommodated due to, my lord, non-availability of the post. So their names were, my lord, recommended to other department as per the affidavit filed by the respondent number 2, which is, my lord, animal husbandry, my lord. On the last occasion, my lord, the government
Lordship,
council was instructed to take up, obtain the instruction.
From the various status of the letter which is sent by the animal husbandry to the other departments, the status is required, lordship. I sent a letter, lordship, 6 some time, lordship. From other departments, some certain.
My case was that, my lord, at that point of time, there was available post was available because I have annexed one advertisement, my lord. Page 37 is the mining.
So you have taken time, Mr. Goswami, on the last date also. 12th of August, you have taken time to obtain instruction.
Lordship.
Then what has happened?
Lordship, I sent the letter to the staff officer of respondent 1, lordship, chairman SLC, lordship. I need some 2 weeks time, further time, lordship.
What do you say, Mr.?
Well, otherwise, my lord, he want to have a query, my lord. But at that point of time, my lord, there are, my lord, almost 13,300 posts was available.
Whether that post or
And that post are new post.
new post, but
So available in the department, in the parent department?
No, other department. Other department.
Therefore, lordship, the status is
I have
clear.
annexed one advertisement, my lord.
That's what he wants.
Yes, lordship. Yes, lordship.
Let it come after vacation.
Yes,
Lordship.
yes, ma'am.
Heard Mr. Anjay of the Lorry Council appearing for the writ petitioners in this batch of writ petition. Also heard Mr. J.K. Goswami,
Respondent 1.
Senior Government Advocate Assam appearing for the respondent number 1.
One,
who
Lordship.
submits that in terms of the recommendation made to the other department, namely the Department of Animal Husbandry and Veterinary, some response regarding the status of the claim of the writ petitioner have been called for, but the same are still awaited. But the response is still awaited. As such, Mr. Goswami seeks posting of these matters again after the ensuing puja vacation, so as to enable him to complete instruction. So as to enable him to complete his instruction. Prayer allowed, let these matters be listed accordingly.
After Diwali vacation. In between puja and Diwali, my lord.
After Diwali.
Lordship.
Well,
So let these matters be listed again in the first week of November.
my lord.
Same order in
Same,
the
up
other
to 32, my lord.
32.
All the, from item numbers 26 to 32.
32, lordship. Same.
I'm obliged.
May I please, Lordship?
May it please, your lordship.
Lordship, this matter may be passed over for timing, Lordship. Senior Counsel Mr. K.N. Sodhi will discuss.
Lordship, here in this matter, Lordship, this morning I have received the records, Lordship. So I need some time to go through the records, Lordship. This.
All right.
Then
The
next,
petitioner's counsel is present on the request of Mr. D. Upamanyu, Learned Standing Council,
Health.
Health Department, Assam, who submits that he has received the records only today morning and therefore is in requirement of some time to examine the same. This writ petition is directed to be listed for admission hearing again in the next week.
Lordship, date may be given, Lordship.
Date is next week, means count the date.
Highly obliged.
May I plead, Lordship? Lordship, in here the respondent number 2 has filed an affidavit in opposition. Lordship, in para 7, the respondent number 2 has admitted that they have they have no any ground to provide the certificate to the petitioner. So they have referred to the case, referred to issue the certificate to respondent number 3. But the respondent 3 has not yet issued me the certificate till then.
Who is respondent number 3?
Respondent number 3.
The private party.
Yes, Lordship, because we have contract with him on with this construction company, Lordship. They have provided us this service. So it's a private dispute, Lordship. And we have stated in our affidavit, Lordship.
No, the petitioner was employed by whom?
By the employed by the respondent number 3.
So respondent number 3 is a private entity.
Yes, Lordship. But
Then what can the state government do about it?
respondent number 2 has directed the respondent number 3 to issue the certificate.
Who is the counsel for respondent number 3?
May I please, Lordship? I'm appearing for respondent number 3, and we have filed the wakalat number, Lordship. 1 week time may be given for affidavit to file the affidavit in opposition.
Your name, please?
R. Sarkar.
I think on heard Miss
A. Pine.
A. Pine and counsel for the petitioner. Also heard Miss A. M. Bhattacharya, an additional senior government advocate Assam appearing for the respondent numbers 1 and 2. Full stop. Mr. R. Sarkar. Give the
Yes,
full name. Full name.
Rohan Sarkar.
Rohan Sarkar, learned counsel has appeared and submits that he has recently filed wakalatnama on behalf of the respondent number 3 and therefore 2 weeks time to file counter affidavit. Prayer is allowed. Let the matter be listed after 3 weeks.
Okay, sir. Item 35.
This is a case where the petitioner was suspended and that suspension order was revoked. On 18/3/2024, my lord. My lord, thereafter he has not been allowed to join, my lord. He's only being paid his subsistence allowance. The last 2 occasions, my lord, Learned Friend took time, my lord, to file reply.
Where is the revocation of suspension?
Page 28, my lord, in extra 6.
That is only the communication, my lord. There is not order of revocation, my lord. Communication to the principal secretary. So we want to take the instruction whether the suspension was revoked or not, my lord. Suspension was issued on 22/2/2024 in view of his arrest, my lord. And that is the communication. The language may not be rightly reflected, my lord. Last line. It is a communication from the examiner to the principal secretary, my lord.
Page number?
Page number 28, my learned friend referred. That is not the order of revocation.
He says now, in accordance with the government's directions, the suspension order has been immediately revoked. So what do I understand? Well, the copy has been given to me also.
What is the date of this order?
My lord, 18/3/2024, my lord. Lordship will see the bottom, my lord. It's clear.
My lord, at this point, 1 week time, my lord, I'll take the instruction, my lord. Whether actually, my lord, suspension order was revoked or not, my lord. If it is a deemed suspension, my lord, and it is required to be communicated, my lord, that is only the point. If the suspension order is revoked,
What
then
are you actually asking for, Mr. Chutia? You think about it and then you want time for what?
my lord, the taking instruction whether the suspension order has already been revoked or not, my lord. If
Supposing it has not been revoked,
then my lord, the 90 days period of 90 days, whether the departmental proceeding is required to be initiated or not, that proceeding will count, my lord, from the date of communication.
Just a minute, when was he suspended?
My lord, 1/21/2024, my lord.
21?
2024.
So can your authorities now take a stand after the judgments of the Supreme Court and High Court
My lord.
That wait here, we are still to take a decision on whether it's.
No, my, that cannot be, my lord. But that period will count.
You will grant you time, you obtain instruction, but he will be paid his full salary on the expiry
Yes,
of
my lord.
90th days, which should be recovered from the salary of the earning official.
My lord.
Only for that,
My lord.
tell us who is the
My
earning
lord.
official.
My executive engineer issued a suspension order, my lord.
Why
and
it
he
has not been
communicated.
revoked?
My lord, that is whether he has issued the order of revocation, my lord. I have no instruction on that.
Mr. Chutia, the court, you want the court to every time pass the same law and
No,
same
my,
judgment?
no, my lord.
There are already
That has
decisions.
been clarified that from the date of communication, it will, the period of
21 to 2024, 90 days will expire.
no, my lord, that is the deemed suspension when he was released from bail and he was required to be communicated to the authority that on such and such date I was released from bail and my lord, then the period of 90 days will be counted, my lord.
So have you not informed?
Inform, my lord. In fact,
When? Inform when?
in fact, my lord, there was a proceeding, my lord, that I had submitted.
No, come to the main question.
Yes,
When
my
did you inform? We'll not go into proceeding. When did your client inform that he was released on bail?
My lord, 8/3/2024.
Where is it? Which page?
My lord, annexure 5, my lord, page, annexure 5.
Page?
Page, my lord, 25, it starts. 24, it starts.
What is
Sorry,
the date
my
of
lord.
this?
Sorry.
An appeal against the order of suspension is page 21.
So in there I had informed, my lord, that I had
preferred an appeal, my lord. And lordship has disposed with a direction to dispose of the appeal also.
No. What is happening is we are being asked to pass judgments again and again and again.
No, my lord.
This
That
time
has
there
already
will be a
been
cost.
That has already been
There will be a
clarified, my lord.
cost because judges are now here to keep
My lord.
writing judgments,
My lord.
same law, same judgments again and again.
I leave it to lordship. Lordship,
You want, no. Who is the officer who is to be penalized for this? Will initiate suo motu contempt.
my lord, the executive in
But because has he informed that he has been, which paragraph he has informed?
My lord, page 24, my lord, paragraph 9, my lord.
there is no executive change in the PWD document card division.
And annexure 4 is the communication, my lord, that I have also annexed.
So he has informed that on 8/3/2024, he has been released on bail. And on 18/3, the executive
Yes.
engineer also informs the principal secretary.
My lord.
After that, no action has been taken in the matter.
No. If he has, my lord, revoked the suspension order as per his, my lord.
Heard Mr. M. Daptal, I'm counsel for the petitioner. Also heard Mr. J. Thutial, I'm standing counsel KSC, who prays for time till 16th of September 2024 to seek specific instruction as to who is the officer responsible for non-revocation of the order of suspension of the petitioner, despite the intimation of his release on bail, as well as the communication dated 18/3/2024, issued address to the Principal Secretary KSC DIFU by the Executive Engineer, PWRD Dokmaka Road Division, Dokmaka. On the request of Mr. Chutia, this matter is directed to be posted again on 16th of September 2024. So what will happen is he will be deemed to have been reinstated on
My
the
lord,
expiry of
my lord.
90 days.
So he is entitled to the full pay and
No, full
wages.
pay.
If he-
Now he has not worked.
My lord.
So that period when he is not worked, his full pay, that
My
component will be recovered from that officer. Let him now face the music. Let him file a writ petition. Let him go up to Supreme Court. Then he will understand what is the pain.
My lord.
Huh? Now, after Supreme Court judgments repeatedly, this court has.
Particularly in this case, my lord, he has to revoke the suspension order, it is required to communicate it. But he has communicated to the principal secretary that suspension order has been revoked. If he suspension order has been revoked, then the examiner is required to allow him to work, my lord. That is the position, my lord. But I have no
No,
instruction.
what we have seen is
My lord.
again and again and again, the same thing is
My lord,
repeated,
my lord,
and
that has
every
been
time a petition comes,
lord.
again and again and
Then
again,
circular has
the
already
High
been
Court has
issued.
to
My lord.
pass judgments.
Now,
The
circular has
petitioner's cases, he is the
circular has already
respondent's
been
case.
issued to that effect also, that regarding the 90 days period, my lord. All over, my lord. Government also issued, we have also issued.
This time is just that we want to make that
My lord.
officer
My lord.
fight cases to get back his salary. so that he also understands how the court order is required. We'll not draw up contempt.
My lord.
We will just direct that part of his salary for those period will be deducted to compensate for the loss suffered.
Whether he is, my lord, allowed to work or not, my lord, that is the only the point. my
So
lord.
you
Yes,
just have to tell us who is responsible.
my lord.
Otherwise, all of them will be treated to be.
It may not be also like that, my lord. He may not join also, my lord, after the suspension or revocation. That may also be, my lord.
If that is the case, show us.
So, on 16, my lord.
We have seen again and again this staple matters.
My lord.
Again and again and again, the litigants are being
My lord.
forced to come to the court on the same point.
My lord.
Suspension, not reviewed, not revoked. The law is well settled. After 90 days, it will be treated to have been lapsed. Still no action has been taken. The court has to pass a judgment in every case. We don't mind writing judgments, but why on the same points?
No, my lord.
There are thousands of litigations pending. We'll write judgments on those. This time there will be a penalty. You do your magic.
No, no.
Whatever you want
not
to do.
basic, my lord. I'll only take the instruction whether suspension order was revoked, he was communicated on whether
No, you must also inform them that the court has asked
yes, my lord.
who
That
is
I will
responsible
inform.
because
Yes,
there will
yes,
be an order.
Yes, regarding issuance of suspension or revocation, my lord.
Item 36.
Lordship. We have received instruction, Lordship, 3 weeks time required to file affidavit.
He says, Borwa Learned Citizen submits that she has received instructions and therefore be granted 3 weeks time to file affidavit. The prayer is not opposed by the petitioner's counsel. In view of the above, this matter is listed again after the Puja vacation so as to enable the respondents to file affidavit.
Item 37.
That is on the same pay, my lord. I have received the instruction. I'll file affidavit, my lord.
Same.
Mr. G. Peggy. Rest is same.
My lord, I pray that since there is no interim, that may be fixed in both the cases. The recipients.
After Puja. Yes, 38.
Here in this case, there is already an interim order against a dependent procedure. Today, only my am seeking.
You want the interim order to be vacated?
No, it should be continued. Today, I am only seeking at the direction again, respond to pay my substance allowance, my lord.
What is this suspension?
Yes, Lordship, and they have got an interim protection also, Lordship.
Only
What is it?
No, this is suspension, Lordship, due to arrest, Lordship. They have been.
Suspension, madam. On the first day, I
The
forgot to-
petitioner was arrested, Lordship, so she was under deemed suspension, Lordship. And there is
The
a intervention.
interim is stay of disciplinary proceeding.
Yes, Lordship. Similar said that's what they were urging, Lordship. So my instruction
Okay,
that
there
means
is a
to be
stay of
required.
disciplinary proceeding.
But there is judgment of the Supreme Court, madam.
Huh?
There is judgment of the Supreme Court, madam.
What is the judgment saying?
Yes, madam.
If it is on the same set of facts.
Yes, madam. Same source of facts, madam. Exactly similar, madam.
Today, what is your?
Lordship, no, we have not received instruction. So my
Mr.
instruction is
Kosa
that 4
to-
weeks time, further time, Lordship.
Ms. M. Bhattacharya, learned additional senior government advocate Assam appearing for the respondents has paid for and is granted 4 weeks further time. to
Lordship.
That
Only
the
with
matter
the
will be
substance
discussed
allowance
accordingly. Interim order passed earlier to control.
The substance allowance should be paid, madam, by the respondent, madam.
Prayer is a place for any granted so and so. Ms. Bhattacharya to also obtain instruction as to whether subsistence allowance has been paid to the petitioner in the meantime, and if not, the reason for not doing so.
My interim order should be.
Interim order passed earlier to continue.
Item 39.
And inspection as well as record I have received, my lord. If required, I'll file affidavit.
My lord, this is a case, my lord, whereby the impugned order, the petitioner, my lord, he was reverted back to a different cadre, my lord. And there was no show cause, no sort of any, my lord, notification, no, my lord, allegations against him. Just as the whim of the, my lord, secretary of the APSC, he was reverted back to a different cadre, my lord. My lord, what happened initially, this man, my lord, this petitioner, he joined as a, my lord, LDA in the, my lord, APSC. Thereafter, he was promoted, my lord, to the senior assistant administrative assistant. And on vacancies being, my lord, there to the post of research assistant, he applied, my lord, and he was a direct recruitee and he was directly
But
employed.
affidavit of the respondents will be necessary.
My lord, they may file, my lord, because on the earlier occasion, my lord, lordship, the court wanted to go through the.
Yes. My lord, he
Perhaps
was
they
in
got the
DN
records.
and DN completed, he was sent back. Now he said they will divert back.
Mr. Chaudhary, is the affidavit required or not?
That they will say, my lord.
My lord,
On the other day, he said when it is.
You want to
not
file
required-
affidavit?
yes,
What Mr. G. Chaudhary and counsel?
in 2 weeks, my lord, I'll file, my lord. I received
Also,
it.
or Mr. T. J.
In the
Mohanty,
meantime, my
senior
lord, I
counsel.
pray, my lord, for my lord, there may be
Already-
interim protection, my lord. My
Already there is a protection given in early order.
Protection is not given, my lord. I may be allowed to continue as a research assistant, my lord.
No, my
till
lord.
this
He
point.
already joined in other post, my lord.
No, that he has been joined, my lord, on the basis of.
Final hearing today itself.
My lord,
If
your
your
lordship
lordship
kindly see, my
desires,
lord.
because, my lord,
But you have said that there is no need to file affidavit. That is
No,
not
yes,
said.
I need to file affidavit, my lord.
Then why aren't you saying that?
Yes, my lord, I want to
As
file.
if the court will say whether.
Yes, my lord, I received the record. That's why I make my
You
submission.
are not asking for time to
Yes, my
file
lord,
affidavit.
time, my lord. I have received the record. I pay for, my lord, 2 weeks time to file affidavit.
my lord, my interim prayer may be my lord, considered.
Today, how can it be done?
My lord, because kindly consider the earlier order, my lord. The earlier order was made, my lord, that without prejudice to my rights, my lord, as pleaded in the petition, my lord, I was directed, my lord, okay, then you will join, my
You
lord.
did not pray for interim order on the last day,
I prayed, my lord.
but
That
it was not granted.
It was, no, it was.
Today, second attempt.
No, not second attempt.
Then
My lord, the records were called for and on procedural records, my lord, the court said that it will be considered today, my lord. That was the last order.
This is the record, my lord. He's revert back and his work is not satisfactory, my lord. And that is for he paid for dim confirmation, my lord. My lord, he was for 2 years and sent back, my lord, his original post. There is no question of revert back. Or the question of, my lord, demotion.
These things of these, my lord, submissions perhaps are, my lord, dehouse the records and dehouse the rules.
I have
and everything,
produced the
my lord.
record. On the
So,
basis
my
of
lord,
record, I
yes,
made
my-
submission.
maybe, my
With
lord,
the
the
record,
rules are
my
there,
lord.
my lord, the rules will say my petition is there, what I have pleaded, my lord.
no, you're, that's not
His-
the law. There is no dim confirmation in the eye of law.
Why, my lord? Kali, there are judgments, my lord. Kali, let me place my judgment, my
Mr.
lord.
Chaudhary, then let them file the affidavit.
My lord.
No, that is why I say, my lord, if, what is my case, my lord? The case which I have, my lord, projected before this court is that, my lord, I belong to a different cadre, my lord. On completion of the probationary period, my lord, there was a deemed confirmation. Now, my lord, without, my lord, a show cause, without an allegation against me or nothing of this sort, my lord, can I be, my lord, reverted back to a different cadre, my lord? The cadre itself is different, my lord. It's not that I was a promotee to this post which I am holding now. I have applied there as a direct recruitment, my lord. I have applied there, I was selected, I had joined. My lord, the rules say that my lord, probation will be for a period of 1 year, which may extend to 2 years, and thereafter, my
Just a
lord,
minute, you were appointed in which post?
I was appointed a research assistant, my lord,
Under?
under the APSC, in the APSC.
Right. That post was advertised.
Advertised.
Where is the advertisement?
My lord will kindly find your page 25, my lord.
Page 25.
My lord.
Page 20.
Yes, all right.
So, my lord, on the basis of
So
this.
wait,
Yes,
where is your order of appointment?
The order of appointment, my lord, page 27.
Page 27, my lord. BNT করতে, BNT.
Yeah. Alright. Order for you, Brazilian for 2 years.
So was it a direct recruitment?
My lord.
It was a direct recruitment.
No, my lord, he was in Lien, my lord. Your lordship can
No,
use
no,
third
no.
will.
Mr. Whether he was in Leon or not is your submission.
My lord.
Let me have the facts first.
My lord.
This,
Your lordship, my lord.
this advertisement was an open advertisement.
Yes, my lord.
Is it?
Yes, my lord.
It was an open
So,
advertisement.
my lord, yes, in departmental candidate. my lord.
So it was a direct recruitment.
Direct recruitment, he was in Lien, my lord. And it was yourself because he's a
Leon from where?
same department. In
You
APC.
can't do it. Then we'll pass an interim order.
No, my lord, your lordship kindly, his lien was granted, now his lien is expired, my lord. Then send back, my lord, he was.
No, he
No.
came in by a recruitment process.
No,
What's the
my lord,
question of lien?
that I'll place your lordship kindly, he's paying for dim, my lord, dim confirmation, my lord.
No,
It is
no.
his payer, my lord.
No.
His payer is for dim confirmation. my lord.
No, forget his prayer and everything. You conducted a recruitment process.
My lord, no,
Then you appointed him.
he applied for lien and granted lien, my lord. Your lordship kindly see page 30, my lord.
How can there be lien if there is
My
a
lord, that was
recruitment?
me non challenge, my lord. Your lordship kindly see, my lord.
You can't take that.
No,
plea.
page, appointment letter, your lordship kindly see. Advertisement also, my lord.
No, you can't take that plea. You issued an advertisement
No,
inviting
my lord, your lordship
application.
kindly say advertisement notification, my lord. The employee, if appointed for the post, will have to resign from or in lien before joining in as per existing rule. Your lordship kindly last line of the advertisement, my lord. Last line of the advertisement, my lord. Your lordship kindly see.
Yes, I've seen it.
An employee of the if appointed for the post, he will have to resign or in lien before joining as a per existing rules. So he applied for lien. He was given like lien, quasi lien for 2 years.
He was given lien by whom?
By the APSC, my lord.
And he was given lien by the APSC to join in APSC.
My lord. Your lordship kindly see that is that appointment order. Your lordship kindly see, my lord. Appointment, his appointment letter kindly see. your lord.
From one cadre to another
Kindly see the
cadre.
appointment letter, my lord. His appointment letter, my lord.
Yes.
Page 30, my lord, 27, my lord.
Yes.
Subject to the reversion without prior notice and without assigning in a region. Thereof, Simanto Nilam Bora, SS Suenso, signed service commission is appointed temporarily the
Well,
research.
you file your affidavit by
My-
Monday. We'll have it on Wednesday.
My lord.
By Monday you file.
And
it.
my lord, this entire thing is as per rule 5, my lord. Rule 5 of the
Mr.
rules,
G.
my lord.
Chaudhary, learned counsel appearing for the petitioner, also had Mr. T.J. Mahanta, learned senior counsel assisted by Ms. P. Sharma, learned standing counsel APSC, who submits that he has received record and will file affidavit within a week's time. Considering the urgency expressed in the matter by Mr. Chaudhary, learned counsel for the petitioner, the respondent APSC is granted time till 17th of 17th of September 2023 to file counter affidavit by serving advance copy upon the respondents council. This matter be listed for order for admission again on 18th of September.
But that will be on 19, my lord.
19th of September.
Till then, my lord.
Yes. Next matter. Give back the records.
For order, item 14.
Prayer for interim release will be considered after the affidavit, counter affidavit is brought on record.
My lord.
Prayer for interim release as made by the petitioner's counsel will be considered.
Now, please, madam. My lord, the matter of this case is regarding non-payment of pensionary benefit to the petitioner, my lord. Yeah, my lord, the petitioner is the wife of late Ishfaqul Hussain, who initially joined as master role labor under the executive engineer PWD Road Kohara division on 1/2/1993, my lord. My lord, he was later on promoted as works as section
On
assistant
the
on
request of Mr. P.K. Majumdar, learned counsel for the lead petitioner, 1 week's further time is granted for filing amended cost item. Mr. P. Nayak, learned counsel for the respondent, PWD is present. Mr. Majumdar, when a writ petition is listed for orders, don't start arguing on merit. You have not yet filed the amended cost item. You have to file it.
Documentary is settled.
Lord, due to maximum urgency, my lord, we have mentioned this matter yesterday. My lord, the present petitioners were the candidate for the post of various posts, my lord. And there are the advertisement. Lordship may kindly see page 39, my lord.
Page 39.
Yes. So by this notice, my lord, the earlier two advertisements were cancelled. At that time, my lord, we were within the age limit.
Lordship, here in this case, I received the instruction, Lordship. I would like to submit an affidavit.
Thing is this, my lord, kindly,
Let it finish.
the examination is going on from Sunday, my lord. I have given the program of the examination, my lord. So the maximum urgency is there.
This is a case of 2023.
23.
Then what happened? You want some interim order?
We want that we should be allowed to participate in the examination. We are not seeking much more thing, only that we may be allowed to participate because there is a cabinet meeting, my lord. Can you-
When was the post advertised?
Earlier it was advertised in the.
No, second time?
19.
Then?
Second time 22. During that time I was.
Before filing the writ petition.
My lord.
So in the writ petition, you did not make a interim prayer to allow you to participate?
No, that was made, but that was not considered. My prayer.
How it can be done? Same prayer?
No, because we were expecting that before commencement of the examination, we will get some order, but till today nothing is, the interim prayer is there, page 21. But here, my lord.
Why they are not allowing you to participate?
You are overaged. But due to our overage, we are not responsible because they cancelled the earlier two advertisements. At that time, we were within our age. That means within 40 years. But third advertisement is made in the 2023. At that time, we became overaged. Now, there is a discussion with the Chief Minister of Assam. Kindly see, my lord, page 44.
So, Mr. Mahmood, this matter you mentioned yesterday.
Yes.
See, the problem is why we will not pass any order today. The problem is, first of all, if we want an interim order at a subsequent stage, there should have been an IA where we would have asked them to respond and file an order. On an oral submission, obviously there will not be any interim
They
order.
have not filed
You know.
till today, my lord.
So what to do? You are not giving the court a chance to pass.
We are not seeking many more, my lord. Only one participant examination.
Nothing is possible. You should have filed an IA. You would have asked them 2 days time to respond and pass an order. That's how
Then
the court
lordship may
functions.
kindly fix the matter on Friday, my lord, and friend would bring instruction. My lord.
Without an IA, it is not possible to file.
IA.
That's how the court proceedings function. You could have, this is the 5th August notification. You could have filed a 2-page IA that allow me to participate.
But there is existing circular of the government, my lord.
Mr. M.U. Mohammed Lawan, counsel for the.
And we'll file a IA.
So, Mr. J.K. Wilson and additional senior government advocate. What was your
Respondent one. Lordship.
What did you submit earlier?
Lordship, I have some instruction, Lordship. Here it is stated, Lordship, the commissioner had given the opportunity to those applicants to appear in the examination who has earlier applied to the elementary, secondary, and higher education technical department because the concerned department had informed the commissioner that the earlier advertisement issued them for the said post for being cancelled and the posts were being referred to the commission recruitment, Lordship. Now here they were given the opportunity earlier they got the opportunity, Lordship. And again they come.
No, my lord, that is not that. We are within our age,
Please
but
for some time.
that was cancelled, well. Well, there is a decision of the Chief Minister, my lord.
That's the problem, Mr. Mahmood. That's why I was asking, why didn't you file an IA? You have prevented your clients from getting relief here. If you would have filed an IA, we would have asked them to respond and pass an order.
There are two phases.
All right, nothing.
Yes.
After
I will
2
file.
weeks.
Of like.
For orders. Item 42.
No, so in this case, SLP has been allowed above the department laws. So I think it survives in the content. Paragraph 28 laws. Paragraph 28 laws.
Where is the judgment?
Lordship, page.
Initial
21.
judgment, my lord, page
21.
1.1.
Where is the single judge's judgment?
Page 9, my lord.
Huh?
Page 9, my lord.
Page 9 of
Contemplation.
All right. So we'll close this.
My lord.
Heard Mr. Chancellor and counsel for the petitioner also, or Mr. S.C. Kyle and counsel appearing for the respondent who has produced a copy of the judgment and order dated 23/7/2024 passed by the Honorable Supreme Court in the case of Union of India and others versus Shishupal, alias Shivpal, in special leave to appeal civil number civil appeal number 7933 of 2024 to submit that the judgment and order passed by the learned single judge as affirmed by the division bench of this court has been set aside and therefore nothing survives in this contempt case. The learned counsel for the petitioner, Mr. K.U. Ahmed, has also confirmed the said position. In view of the above, this contempt case stands closed. IS stands disposed of. Accordingly, IS stands disposed of accordingly.
In the earlier occasion, this honorable court has allowed me to implead and
You have to file impleadment application.
my lord, I will.
You file.
No, my lord. Please, my lord, 2 weeks time may be given for
Alright.
filing.
On the prayer of Mrs. S. Bapatra Goel and counsel for the petitioner, 2 weeks further time is granted to the petitioners to file impleadment application.
My lord.
This is the matter accordingly. None appears for the petitioner on call. Matter stands passed over for 2 weeks. Yes.
Your Lordship, we are unable to establish any kind of communication with the petitioner. So kindly the matter may be adjourned.
You are appearing for?
My lord, the MD has been changed, my lord, so they need to substitute. Respondent number 1.
Mr.
H.K. Sharma.
H.K. Sharma, learned counsel for the respondent number.
1 minute.
One submits that the MD of the
ASTC.
ASTC has recently been changed and therefore substitution of the MD is necessary in this case. Full stop. Responding to the above, Ms.
Ms. D. Bangsheri on behalf of Mr. S. Sidas.
Mr. Esidas submits that he has not been able to establish contact with his clients and therefore this matter be adjourned for 4 weeks so as to enable him to obtain necessary instruction. You are there in this case?
I am, in item number 44, Lordship.
On the request of petitioner's counsel, this matter stands adjourned for 4 weeks. And what is there in item 44?
I have received the instructions, Lordship.
Acha. What is the instruction?
Just now my file has been replaced, Lordship, here.
Ms. D. Learned counsel for the respondent is present. However, since the petitioner's counsel is absent today, let the matter be listed after 4 weeks. We'll see when it comes. You keep this with you.
Yes, Lordship.
Item 46.
This order, case.
Mr. D. Borua Learned counsel for the petitioner submits the order of the court has been complied with and therefore the contempt case be closed. Ms. M. Kotoki, Learned counsel for the respondent is present and confirms the said position. In view of the above, this contempt case stands closed.
Obliged, Lordship.
Item 47. None appears for the petitioner on call. Mr.
My instruction is complied, Lordship.
A. Upadhyay, Mr. N. Upadhyay, Learned counsel for the respondent number.
1 and 2.
1 and 2 submits that the order of this court has already been complied with. Taking note of such submission of the learned counsel for the respondents, this contempt case stands closed.
Obliged.
Is there a IA? IA in? No. Item?
My lord, I am not pressing, it has complied.
Mr. S.K. Bose, learned counsel for the petitioner submits that order of the court has been complied with and therefore the contempt case be closed.
I'm Mr. D. Kolita, on behalf of Mr. D. Nath.
Look, we'll record only one name on behalf system. Whose name?
Mr. D. Nath.
Mr. D. Nath, learned counsel for the respondent number 1 and Miss D. Neo, learned counsel for the respondent number. You have 4?
No, only one.
Actually, only one.
Only one.
Mr. D. Nath, learned counsel for the sole respondent is present. In view of the submission made by Mr. Bose, this contempt case stands closed.
Okay.
In this case, my lord, I have taken steps, my lord. But ID card, my lord, not returned, my lord.
Await service report on respondent numbers 2, 3, and 4 for another 2 weeks. Mr. So-and-so is present for the petition. SSS Rahman is present for the petitioner.
File affidavit today. So I want to file, reply. Let it come after very.
Mr. Purkas, the learned counsel for the petitioner submits that he be granted 2 weeks' time to obtain instruction and file rejoinder to the counter affidavit filed on behalf of the respondent number 2, a copy whereof has been served upon him only this morning.
I'm respondent number 4.
That's what I'm saying.
Ms. A. Bora, learned counsel for the respondent number 3 and
Miss
Ms.
S. Das.
Ms. S. Das for respondent number
4.
4. Who is for respondent number 2?
Government.
Huh? Who has filed the affidavit? Respondent number
4.
4 has
Yes,
filed.
Your Lordship.
4, huh? Not by 2. The learned counsel for the respondent numbers 1 and 2 are not present. Are you state of Assam? Are you not present, Mr. Goswami? Learned Standing Council Health Department Assam is present for respondent numbers 1 and 2. On the request of petitioner counsel, this matter is directed to be posted again after the puja vacation.
Yes.
We will finish the list.
May it please your lordship. Yesterday, my lord, I had filed my wakalatnama, my lord, for respondent number 1, 3, and 4, my lord.
Ms. R.S. Devi, learned counsel submits that she has filed wakalatnama in this case on behalf of respondent numbers 1, 3, and 4 and prays for 3 weeks' time to file affidavit. Mr. You are there?
Yes, sir. I'm respondent number 2.
Mr. H. L. A. learned counsel for the respondent number 2 is present and prays for further 2 weeks' time to file affidavit.
Bring up to date instruction.
Huh?
I'll bring up.
All right.
Actually, we have filed the representation on the very last petition.
All right. Mr. A. Burwa, you are A. Burwa.
A. B.
right?
Datta.
Huh?
A. B. Datta.
A. B. Datta, learned counsel is present for the petitioner on the request of respondents. On the request of respondents counsel, let this matter be listed again after the puja vacation. In the meantime, the respondents counsel to obtain instruction and file affidavit if so advised.
Obliged.
In this matter, the respondent has supposed to file affidavit. Earlier, when they submitted that they have obtained the instruction, but
Who is the respondent here?
health department. D. Boras.
So where is Ms. Bora? What is this matter about?
Matter is without publishing selection list, 3 persons appointed by the authority.
Okay, we'll have it next week again then. Or Ms. P. Bora, learned counsel appearing for the petitioner. None has appeared for the respondents, although the name of the learned standing counsel health department is shown in the cause list. Registry to therefore list this matter again after a week for orders. That's it.
May it please your lordship. Lordship, this matter, my lord, the Lazima court has already directed us to take steps to dismissal as regards respondent number 6.
So you will take steps.
My lord, we'll take steps. This was order dated 9/9/24 of the Lazima court.
Mr. H. Betala, learned counsel for the petitioner submits that as per the order dated 9/9/2024 passed by the Lazima court, he would take steps for service of notice upon the respondent number 6. by registered post with AD within a week from today.
Through Dasti, they have registered, we have already taken, Milord.
Hmm.
This was through Dasti, Milord. There is a direction by the Lazima.
Take steps to serve notice upon respond number 6 by means of Dasti within a week from
Within a
today.
week.
Mr. Betala submits that steps by registered post has already been taken. Mr. J.K. Goswami, Leonard, additional senior government advocate Assam.
For
is present
respondent
on
one.
behalf of the state. Office to verify and list the matter again after 3 weeks with appropriate note.
Highly authorized.
Lordship, I appear for respondent 1 to 4.
Who is the petitioner?
Petitioner, Your Lordship, JMA Chaudhary, Councilor Lordship.
None appears for the petitioner when the matter is called up. Mr. G.J. Bordoloi, G.J. Bordoloi, G. Bordoloi, Leonard, Standing Council Cooperation Department, Assam, is present.
For respondent number 1 to 4, Your Lordship.
For respondent number 1 to 4. However, since the, why is this been listed today?
There's a private respondent, respondent number 5, Your Lordship. I think it's regards to the service upon the respondent number 5, Your Lordship.
However, it appears that no steps for service on respondent number 5 has yet been taken by the petitioner's counsel.
In fact, Your Lordship, I have not been served by the extra copies also. Petition.
Mr. Bordoloi submits that even extra copies of the writ petition have not been furnished to him. In view of the above, 10 days further time is granted to the petitioner as last chance for taking steps in the matter, failing which consequential orders will follow.
Public.